Hello, this is Steve Rinka from the Rinka Law Firm. I'm here today to talk to you about written discovery. Written discovery is a method upon which opposing parties seek to gather information from the other side. There are different types of written discovery. The most common forms are form interrogatories, which are actually pre-printed documents that have questions that have already been approved by the California State Legislature. And these form interrogatories can be located on the California Court Forms website. In addition, with form interrogatories, there are actually different types of form interrogatories for the different types of causes of action. You have general form interrogatories, which apply to most typical lawsuits such as personal injury, employment, business disputes. But in addition, there's also form interrogatories for employment law, form interrogatories for construction litigation, family law, and a couple other different areas, unlawful detainer, that you can use form interrogatories for. In addition to form interrogatories, there are also special interrogatories. Now, under California Code of Civil Procedure, you are limited to asking 35 special interrogatories. If you want to ask more than that, you have to set forth a declaration explaining why you want additional interrogatories. If you seek too many interrogatories and there's no good basis for the number of interrogatories you're seeking, the opposing party can go before the court asking for a protective order, requesting that the court limit the number of special interrogatories. Typically, this would be an extreme measure. It doesn't happen all that often, but sometimes the other party may be trying to harass the opposing party by asking an extreme number of special interrogatories as a method to try and get the parties to settle the case or get to a negotiated settlement. Under those circumstances, it would be appropriate to seek a protective order. Another method of written discovery is called requests for admissions. Requests for admissions are straightforward questions where you're asking the other party to admit to a certain fact. For example, you could ask, admit that you were the driver of the vehicle involved on the car accident on such and such date. And in that situation, the party responding would either say admit, in which case that fact is admitted, it's not disputed, it's essentially stipulated between the parties, or the party denies it. Now, if the party denies a simple admission like that, there's a question box on Form Interrogatory General 17.1 that then asks the party, if they deny a request for admission, to set forth the facts that support this denial. So in the instance of somebody denying they were the driver, then on Form Interrogatory 17.1, they'd put in the response the number of the request for admission they're denying, in this instance, let's say 1, and then it'll ask, set forth all facts that support your denial. And in that section, you would set forth, the responding party that is, the name of the driver, if it's not the party responding, who was driving the vehicle at the time of the accident. Now, this can be a very effective way to get to the root of the causes of action by doing a request for admission, because they're very straightforward, and it really allows the parties to get to the meat of the claim. It doesn't allow people to extrapolate or expand on answers. It's a very straightforward admission or denial. Obviously, you're going to have situations where the other party tries to object and not fully answer it or directly answer it, but in that situation, you can bring what's called a motion to compel, asking the court to require the other party to provide a very straightforward response to that request for admission. Another type of written discovery is called a request for the production of documents. And in this particular form of written discovery, you are setting forth questions or demands, I should say, asking for particular sets of documents relating to the lawsuit. So in an employment lawsuit, for instance, you would ask for the employee's employment file. You would ask for any sort of handbook. You would ask for any write-ups that the employee who's suing was involved in, any commendations that the employee who's suing received. So it's essentially a way to obtain this type of discovery, these documents, in a very efficient, effective manner. There's no limitation on the number of documents you can request. So unlike special interrogatories where you're limited to 35, and that's the same for requests for admissions, you're also limited to 35. Otherwise, you need to set forth a declaration. But with requests for production of documents, there's no limit on the number of requests for documents that you can ask for. So if you want to ask for 100, that's fine. You don't need to set forth any sort of declaration explaining why you want to do a request for 100 documents. So the courts seem to, or the legislature seems to believe that requests for the documents is not as taxing or challenging on the other party as answering interrogatories, and I would agree with that. The request for documents, either you have the documents or you don't. If you do have the documents, you're best to produce them, because if you don't produce these documents, you could be precluded from introducing these documents at trial. So the surprise element is not a good practice to operate in anymore under the current rules of evidence. A lot of times, if you don't disclose these documents ahead of litigation or ahead of the trial, the court's going to sit there and they're going to say, you can't introduce it. We're not going to allow the surprise evidence. The only time you're going to be allowed to provide quote-unquote surprise evidence is if you're trying to impeach a witness. And in that situation, too, you have to be careful that this evidence isn't relevant to some other type of document request. So the best practice is to provide all documents that are responsive in order to avoid being precluded from introducing these documents at the time of trial. So those are the primary forms of written discovery. The other form is issuing subpoenas, but that's different because subpoenas are being issued to third parties. They're not being issued to the other side. To get documents and information from the other side, you just engage in written discovery. If you have any questions about written discovery, in particular about form interrogatories, special interrogatories, requests for admissions, and requests for production of documents, you can contact me, Stephen Rinka, at 310-556-9653. Have a good day.